Good evening, everyone. Good evening, ma'am. First
Good
of
morning.
all, congratulations to all. I've received, I have reviewed your complaints from week one, and you successfully argued that a slap and a death threat constitute cognizable offenses. You forced the system to act. Because of your strong drafting, the police had no choice but to register an FIR against the builder. But in criminal law, winning isn't always about sending someone to jail. Sometimes winning means getting your client their due and closing the chapter peacefully. The accused, terrified of the criminal cases, has surrendered. He has apologized and paid the money. Our client Aryan is happy and wants to end the fight. But here is the legal trap. Once an FIR registered, it becomes the property of the state. The police cannot close it just because the victim says it's okay. The magistrate cannot close it easily. Only one power can wipe the state clean, the High Court. So your next task will be of questioning the petition, draft the petition to quashing the FIR. Ma'am will begin. Ma'am, you may start with you.
Hi, good morning, all. Good morning to all the students, and thank you so much to Nyayavani for inviting me to give a lecture on the same. You are doing a great task and with great enthusiasm, especially all credits to Deepak, and especially on a Sunday morning. You people are all enthusiastic, young lawyers working for the betterment of the society. So, before I begin with the problem, I would like to put in the notice of that throughout an case, and my judgment, and that judgment is of Haryana versus Bhajan Singh, right? So, uh, my reason of start judgment, I won't go into a very much of detail, but the principle of quashing of FIR was actually started and laid down in this judgment, and this is a old judgment that is of 1990, where uh, the Supreme Court gave a landmark they gave a landmark judgment, and they talked about the quashing of FIR, where the quashing of FIR can be done, and where what are the circumstances where the FIR could be quashed, right? So, talking about this judgment, I'll just give a brief overview of this particular judgment, and just give me 1 minute. Yes. Sorry for the delay. So this case have been a landmark in the legal history, right? Indian legal history, it's been a landmark, and it is concerning to the quashing of FIR. And what exactly we mean by the quashing of FIR? Here we would study very much of detail quashing of FIR, and what we're talking about the inherent powers of the court that have been given. And talking about this judgment, here the Supreme Court basically said that if there are certain grounds which does not mean, does not meet the ends of justice, there the court does have a power where they can quash the FIR, right? So this special power has been given on the High Court, right? So the inherent power which was earlier in 482. Now the section have changed. We'll be talking it in detail in the BNS and the BNSS. The sections have been changed. So, but it gives the inherent powers to the High Court, and there have been certain circumstances where this quashing of FIR can be done. So we are balancing, we don't want that there is an abuse of legal process. Okay. The legal process is given to the client in order to, give them justice. But if anybody, abuses this power, so here it puts control over the same. We have certain powers in the Article 226 as well. When we talk about the Indian Constitution, it empowers the, it empowers the High Court to issue certain writs. And similarly, when we talk about the Bhajan Singh case, here actually the questions were, few of the questions were where the allegation are prima facie constitute any offense or not. Whether the prima facie allegations here disclose the cognizable offense or not, whether there are enough of evidences or not, all these questions were taken in account by the court. And in conclusion, when they saw there, it was given and the guidelines said that whenever the FIR is lost, that should be prima facie, it should have some grounds, right? And if there are no prima facie grounds, and if prima facie, it does not constitute any kind of offense, yes, it does not disclose any kind of cognizable offense, there the High Court to certainly have a power to quash the FIR. Okay, so we'll be studying some more cases regarding that. I would begin with my presentation, and if the moderator allows, I would like to share my PPT as well. Can I do so?
Yes, ma'am.
Yes, I'll just do that. Just give me a second. So is the PPT visible? Is the PPT visible, Tisha?
Yes, ma'am, it is visible.
Quashing of FIR. Okay. So I'll just, without wasting any of the time, I'll just begin with the, I'll just begin. And before we begin and we go to the main topic of the session here, I would like to discuss what exactly is FIR. I am sure the interns have done their part, and I am sure Deepak and his team is doing very great. And आप लोगों ने सब समझा दिया होगा इन लोगों को अभी तक what exactly is FIR. I know that. But before I begin with what exactly the quashing of FIR is, I would like to give you a brief overview of what exactly is FIR. Right? So it is the first formal information that you give to the police, yes, about a cognizable offense, and it is recorded under Section 173. And the copy of FIR should be sent to the nearest magistrate within the time period of 24 hours, right? And it is an official record which initiates the criminal proceedings. Yes, so I am sure the students also know there is we are having a civil case and a criminal case. Here we are talking about criminal proceedings, and criminal proceedings here totally have the BNSS directs the procedure of the criminal proceedings. And when we go to the CPC, it talks about the civil suits and the other things. And the FIR can be lodged by the victim himself or herself or by any person on his or her behalf, right? And it is mandatory whenever the FIR is lodged. The copy of the FIR is given to the accused as well. So, without wasting any kind of time here, uh, coming to the quashing of FIR, right? So, FIR basically quashing means to set aside the FIR. So now though we have registered the FIR has been registered, the criminal proceedings have begun, but at some point of time we found that there is a problem with the FIR. By problem, I meant maybe the offense, it should not be registered. Maybe somebody is abusing the process of law, or maybe somebody has some kind of grudges due to which he lodged an FIR, but there is no specific or prima facie ground to it, right? So, talking about the quashing of FIR, we are saying that we want to set aside the FIR, right? And exclusively, I will stress upon this point again, that exclusively we have given this right to the Honorable High Court, right? Talking about the very important section here the important section is section 528 of the PNSS, and the FIR may be quashed when? What are the circumstances where the FIR will be quashed? We will talk it in detail, but to summarize it and to cut it short here, if the dispute is of such a nature that it is of a personal nature, of a private nature, where the two individuals are involved, right? Or the other point can be if the proceedings or the criminal proceeding proceeds, it would be totally abuse of the process of law, right? And talking about quashing of FIR, it generally does not permit. It does not permit the serious or the heinous crime. Because when we talk about the crime here, we say that though it is done against a person, but we say that crime affects the people at large, the people of the society. So talking about serious and the heinous crimes, generally, which affects the society at large, we do not consider this quashing here. But quashing of FIR can be done where the dispute is of a private nature or of a personal nature where two individuals are affected to it, right? So the main objective here is to secure the ends of justice, right? At the end of the day, be it a civil proceeding, civil suit, or a criminal case here, at the end of the day, we want that justice should be met, right? So coming to the legal provisions, yes, to the legal provisions of the quashing of FIR, which you people should know, because at the end, when you draft a quashing petition for the High Court, which I do have some sample petitions for you here. So, first, you should know what exactly are the legal provisions to it, right? So, talking about Section 528, yes, 528 of BNSS, here it empowers. Yes, the High Court has the power to quash the FIRs of the criminal proceedings to prevent the abuse of the process of law and to meet the ends of the justice. Here, I would also like to, tell you and include another very important article of our industry, the Constitution of that is Article 226. Yes. So here the Article 226 here, the High Court has the power to issue writs in appropriate cases and quash FIRs also. So these are the inherent powers of the court. So before I move forward, I would like to tell you what exactly is meant by inherent. Inherent is a very, it is a very important word, and which says that inherent basically means by the virtue of being it. The High Court, by virtue of being a High Court, have certain powers that are specially vested upon the High Court. These are extraordinary powers which are vested upon the High Court here, inherent powers. And quashing is an extraordinary remedy. Yes, it is. And it is used, it's not that it is a day-to-day business of the High Court that every other cases the FIR has been quashed. It is used sparingly, yes, in certain special cases where we can see that the ends of justice is not being met or the process of law is being abused, right? And talking about some important judgments here, first is Bhajan Singh, that has been a landmark judgment. And one detailed judgment that I will be discussing with you people, because it is related to the compromise deeds as well. And I think the problem that is given to you people is related to the quashing and the compromise deed of the party. So there are certain judicial precedents which I'll be talking about, and one of which would be Gyan Singh versus State of Punjab here. So before I move to the important judgment here, uh, the quashing of FIR is whether it is justified or not. Yes, you being the lawyer, when you frame the petition of the quashing petition here, you should know all these points because that's how you're going to justify your point to the honorable high. So talking about the quashing of FIR, first of all, it's very clear on your mind that whether the dispute is of a private nature or a civil in nature, or whether it is of such a nature that is affecting the society at large. Yes, sometimes the parties amicably try to settle the disputes between them too, right? The parties, the dispute between whom the dispute was, they try to amicably settle between it. And there is no element of a serious violence in this, yes, moral depravity, or it is not in the public interest. So, if such kind of FIR continues, that would certainly be kind of a burden to the judiciary. If this kind of is the nature of the case is such that I have told in the previously, then they can settle the things between them too. Yes, the pressure of the judiciary will also be lowered down in these cases. But I'm again repeating myself and not talking about the cases which are affecting the society at large or which are of a cognizable nature or of a very serious nature. Yes. Now, talking about the abuse of process. What do you mean by the abuse of process here? So we know that we have certain laws. We have laws, we have criminal laws, we have civil laws. Yes. So these laws are there for us for the purpose of justice. But if we abuse this process, then what? Yes. So FIR amounts to the abusive process if, first of all, the party who has filed the FIR has a malified intention or an ulterior motive to it. Malified intention certainly here means that maybe that party has some kind of grudges against the other party. For that, they have hoaxed the FIR and filed that FIR, right? So the other point could be that they are just using to harass or threaten or pressure the accused here. It is not genuine. They're trying to harass them. They're trying to threaten them. Or maybe they're trying to put a pressure on them, right? So it could also be that the dispute is actually not of the criminal nature, but it is of a civil nature, which is affecting two parties, right? And it could be allegations, even if as is true, but not disclose any kind of offense. To become an offense, as you know, that there should be a ground that yes, this offense have been caused. So if this such kind of an FIR continues, that would certainly result in unnecessary harassment and totally wastage of time of the judiciary. So you can say, for example, there has been a money dispute and there have been a a slight hurt to that particular person also. The matter, there can be matters which are already been settled between the two people, still they are filing an FIR. Then what? Then what? Then actually purpose of the FIR is lost, right? So therefore, the quashing of the FIR could be considered, right? So specifically talking about the compromise cases here, I have taken this case here, and I suggest I would be giving these cases to your respected convener also, so that he could circulate it to you. Maybe he has done it already. This case is very important here. Gyan Singh versus State of Punjab, as well as Narendra Singh versus State of Punjab, where High Court's power to quash FIR is independent on compounding provisions. They have said this. Well, so FIR can be quashed on settlement, even if the offense is non-compoundable. So they have said this. Court, what will the court consider? First of all, let's see. If you are on the other side of the story, what is the things that the court will consider in your case? First, it would be what exactly is the gravity? What is the gravity of the offense? So, what kind of offense it is? What kind of gravity? Is it a grave offense? What kind it is? It is it a minor offense? Or whether the dispute is of a personal or a private nature, whether it is affecting the society at large. At the end of the day, we see that whether the society is being affected or not. Yes. So the test applied here. What is the test? What is the judicial mind that they apply here? It is whether continuation of FIR would be the process, would abuse the process or defeat the ends of justice. So here, the role of the court comes here, and they see whether this such kind of frivolous FIR, or you can say a FIR which does not have any kind of ground, continues, will it abuse the process, or will it defend the ends of the right? So here, so it is an old case that is of 2012. So that time we were following CRPC, and in the old cases we do mention the same sections, and that is 482. And on here, basically, it has said that to quash criminal proceeding on the basis of compromise, on the basis of compromise between the, so compromise can be how? What do you mean by compromise? That you try to settle the deeds, your terms and condition between the two parties. And predominantly, it could be compromise generally occurs in the civil nature, and sometimes it could occur in private nature also. For example, matrimonial disputes, it could be, there could be family dispute and some commercial matters as well, right? But when you talk about, you say, ma'am, that there is a murder, there is a rape, there's a dacoity or corruption, certain corruption charges have been put against a person, huh? Or there are some offenses that are obviously affecting the society at large, cannot be, cannot be quashed merely on a compromise, right? So I again stress upon one more point here, that the nature and the gravity of the offense is fully and carefully examined by the honorable court, right? So the stage of proceeding is not decisive, but compromise can be considered, even considered. I'm saying it could be considered even after the charges are framed. Right? You know what is charge framing? A charge sheet is filed. Yeah, the charges and allegations are put. But if the court feels that the process of law is being abused, even after that, it could be after the framing of the charges, it could be considered. Yes. And first of all, the compromise, if between the parties of is of such a nature, it should be voluntary. Voluntary, that means that should not be done in any kind of pressure, right? It should be genuine. And it should be free from any kind of coercion, yes, and any kind of undue influence. And talking about this, the primary test is that if this proceeding continues, the ends of justice would not be met, and it would certainly result in the abuse in the process of law. So, whenever we file this petition, also, maybe if we use these words, I'll be sharing the petition also with you people. If we use that, my lordship, if may pray to the honorable court that if the FIR is continued, the proceedings would serve, would the proceeding would abuse the process of law. Therefore, it is requested by the honorable council to quash the FIR. That's it. Yes, when we go into the practical life. And talking about public interest and societal impact, this is one thing that is always kept in the mind before quashing the proceedings. The judiciary do keep this in mind, that whether the public at large is being affected by it, or it is affecting the society, and what exactly would be the impact if I quash the FIR, what would be the impact to the society, right? So these are certain categories. So where it could be quashed, or where the judiciary would not consider it to be quashed, right? Even if and even though they are compromised, right? So you can have a simple look on that. So as I already told in the beginning of the lecture, murder, rape, dacoity, and offenses that actually, affects the society at large, even though you compromise with it, but still it is affecting the society at large. So these are generally not quashable. And sometimes these there are other settlement that could be done in certain of the cases where the quashable on settlement are cheating, maybe simpler matrimonial dispute, financial transaction, that would be right. And coming to the next. The case that have been given to you, though I have not read it in very much detail, but I do have a certain idea about it as shared by your mentors here. So, FIR, if arises from a private dispute and if the allegations involve financial transaction, a simple hurt, and condition being the parties are voluntarily settled, and there is no societal or public impact, the FIR is fit to be quashed, right? And coming to compoundable offenses and quashing of FIR, and there are two kind of offenses which could be compounded, and there are other that could not be compounded when you study in detail in the BNSS. And compoundable offenses are basically compoundable offenses. Compounded are always compounded before the honorable magistrate, and they are limited to certain kind of sections. There are certain sections where the compoundable offenses are given, and the procedure remains the same. But quashing of FIR, again telling the difference between the two, that quashing of FIR is done by the High Court, and FIR and all proceedings are, and when the FIR is quashed, then all the other proceedings are also set aside. And there is a clear legal record, and there is no other record. There is, if the FIR is set aside, the proceeding is set aside. So the legal record is restored and it is clean, right? And why? Why do you prefer? And the question here is, what is the need? What is the need of quashing the FIR? Why? So, first of all, it stopped criminal proceedings at an early stage. You know, it's the judge, it's the advocates, it's the parties, the whole process that continues till the end. There are the criminal proceeding, when you talk about the whole proceeding, the evidences, the examinations, the witnesses, and everything, that is a total long process that we follow and that should be followed in order to prove the innocence, or if the accused has done wrong, he would be convicted. Yes, but if it is not so, if the FIR is not genuine, then it stops the criminal proceedings at the earliest stage. So in order, it also at some point of time, depending upon the facts and circumstances of the case, the it avoids arrest, trial, and prolonged litigation. So, no, here, prolonged litigation certainly means litigation should be done where the cases are genuine, but where it is not so, there litigation can be prevented. Prolonged litigation can be prevented by quashing the FIR. It certainly and certainly saves you judicial time, and it very important, it protects the liberty and the reputation of those particular parties who have been alienated. Yes. So if the FIR is not justified and it is found by the court that it is groundless, and the prima facie we have seen that it does not amount, it does not have any kind of case there. So there, if it has been quashed, the liberty and the reputation of the parties which have been at stake is, it which have been in stake is protected. So coming to the role of the High Court, what is the role of the High Court? Yes, we know that the Supreme Court is our guardian, but yes, we have a very important part where we have a very important role of the High Court as well here. Yes, it as of the guardian, it is a guardian, and it helps is a guardian against the misuse of the criminal law. And here somewhat the High Court balances the individual justice, the societal interest, and ensures that the criminal law is not used for the private vengeance. So private vengeance certainly means here, if we have any kind of personal grudges against the person, and for that sake we have filed an FIR, then it would be certainly quashed by the High Court, by the Honorable High Court. So concluding, I would, after the conclusion, I would show you a petition as well here. And coming to the quashing of FIR here, so I would just like to conclude here that FIR should not survive when, what are the circumstances? When the dispute is private and they have settled it personally and parties have settled it. No public interest is involved here. The society at large is not affecting. If the dispute is being settled between, amicably settled between the two parties, the public at large is not being affected. And of course, Section 528 is very important because that is the section where these inherent powers, these special powers, these powers are being given to the High Court in order to meet the ends of justice and end the unnecessary prosecutions that have been there in the system. And justice, as you see, there is a very important, you know, maxim there that the justice should be seen. Yes, the justice when delivered should be seen. दिखना चाहिए कि एक बार जब justice हो गई है, then it is genuine and it is seen that yes, justice has been delivered. So here I would conclude in this particular topic here that the delivery and real effective justice is given to the people of the system, because actually that is that is, that is the main purpose of following the whole procedure. Why is BNSS made? Why was CRPC made? Because it was following the criminal procedure code. That is why they wanted to, the court ensured that yes, this process is followed. Innocent should not be hanged, and if the accused is there, he should certainly be a convict. So therefore, there should not be an abuse of the process of law. Okay, so I would end here, but before that, I would like to show a sample, a sample of a petition that it's a real sample that have been filed before the Honorable High Court, and it is filed by a senior advocate of High Court of Uttarakhand that I have been, he's my senior and my mentor, and I'll just give a sample of the petition that have been really, which have been filed in the Nainital High Court. I have certain other samples also. So here, as you see, so this is a sample here, talking about the case categories here, and I'll just move to the main part of the here. So this, petition have been filed in the Honorable High Court of Uttarakhand. And here the category that have been given to such kind of petition is the criminal miscellaneous applications, right? It is under this category, was somewhat filed in 2024. And they have mentioned here, whenever you write the name of the Honorable Court, the kind of the category here, then you write the section, under which section you're filing the FIR. Then coming to the place where you filed it, then coming to the parties. These are the this is the format. This is a quashing petition that have been already filed, and so you have the name of the parties, you have the applicant here, and the respondents here, and you write the names of the parties along with all the details as you already know. So you're writing it to the Honorable Chief Justice and talking about, you give all the reasons, what do you want, and talking about the full facts and circumstances of the case. You do file a affidavit also along with this, and talking about all reasons and everything, you write it because you have to give an affidavit also, because whatever you are saying, that is true. Yes, talking about the quashing here, they are talking about the quashing of the charge sheet as well, and then they are talking about some other orders also which have been already passed in this particular case. And at the end, they are also so this case was somewhere in the later stage. So they are saying that entire proceedings of this criminal case should be quashed out. And talking about the prayer, you write whatever what you exactly want. Prayer is a very important part of the petition, of each petition you file. And in the prayer, you actually write down what actually you beg from the honorable court. And here you will write that, and with, if you want, talking about the specific FIR or talking about the charge sheet also in this particular case, you write the charge sheet number as well as the FIR number here, right? And then you're talking about the quashing and set aside uh, of the orders, some of the orders also that have been filed, that have been given by the courts in this related to this particular case. Then they're talking here about quashing of the entire proceedings of the criminal cases here also. And so you have the name of the advocate also. You have the name of the advocate here, which I'm talking about, and is the counsel from for the applicant. Then attached to this, there is a affidavit as well, right? So this is a sample. I will be sharing the sample with your mentors here, and that's that's it from my side. As I would just suggest that read read uh, the sections properly. See actually what we study in our classes, and when we what we study practically, what we do practically, things are very different, right? I could only give you the points which as a lawyer which you should keep in mind. But the internship program that Nyayavani is Foundation is doing, that is giving you a practical, experience, and they are teaching you what exactly you will see, what exactly how you will draft when you will go to the court. And that just give me a second. Yes. So here I would just like to conclude that whatever you're doing, if you're drafting things here and you're learning in your internship, that would certainly help you in the practical life, that you will be actually facing it as an advocate when you go to the courts. And Nayavani, you are doing a great job for teaching these young lawyers how to face the court. And thank you so much for calling me. And I would just, rest my case here. That's it from my side.
Thank you so much, ma'am. And it is a absolute privilege that we are having you here. So I like to introduce you to our interns. That ma'am is currently an assistant professor at the School of Legal Studies, Jigyasa University, Dehradun. Her academic credentials are nothing short of inspiring. She is a gold medalist in her LLM constitutional law and holds a PhD on a deeply critical topic, a socio-legal study of the prison system and its reforms. This gives her a profound understanding of the criminal justice system from the inside out. But she's not an academic. She is a champion of practical skill. As a convener for national moot courts and youth parliament, she dedicated her career to ensuring law students don't just read books but actually sharpen their advocacy and leadership skills. Today, she brings that expertise to us to decode Section 528 of the BNSS. In turns, you are learning from the scholars who has mastered the theory and the practice. Thank you so much, Dr. Falguni ma'am. That was a master class. You simplified a very technical concept, the inherent power of the High Court, into something so practical. We now understand a settlement between parties is useless unless the High Court puts its stamp of approval on it. So, ma'am, here are some questions of the interns. We like to address it all.
Yes, please.
Good morning, ma'am. Chaya, right?
Yes, good
So
morning,
I will
Chaya.
Q&A section from the group chat. Okay, ma'am. So the first
Yes.
question is from, why is the power to quash FIR vested only in the High Court and not in the subordinate court?
Yes, that's a great question. And certainly, uh, seeing here, Chaya, my answer to this would be High Court is like a custodian. Yes, as again said, I would reiterate the same, that it's like a guardian. Yes, all the subordinate courts do have certain powers, but there are certain inherent powers that can only given to the higher courts in the hierarchy of the criminal justice system. Right? Seeing into the gravity of the situation and seeing to the seriousness of the nature of the quashing of FIR. Right? So every third person cannot do that. Yes, as I said, that it is sparingly used. It is sparingly used in only certain cases. So here, my submission to this would be that these inherent powers are some special powers. These special powers cannot be given to all the lower courts, but only to the higher court to meet the ends of justice, so that it could be only used in certain cases which needs justice, and these inherent powers should be given to the high courts only, so that the due process of law is followed in the lower courts. But if there is a doubt that the ends of justice has not been made, then only the high court intervenes.
Okay, ma'am. That is absolutely true. The second question deals with
Yes.
why is quashing said to be an exceptional power? Why can't court freely quash a bad cases?
Can you please repeat what is the word that you're using? Can you please tell me the word and what kind of power?
Uh, Ma'am, like the why is quashing said to be an exceptional
Yes.
power? Why
Exceptional.
can't
Yes,
court?
yes.
Yes, ma'am. Why can't court freely quash a bad cases?
Yes. Now talking about, when you say bad cases, now this term can be, you can, when you literally see it, how can you, differentiate between what is the definition of a bad case? When I talk about here, quashing of FIR in a certain exceptional cases where there are not prima facie facts which shows that there is a cognizable offense that has been made, or in certain case of, settlement here. So quashing of FIR is only for some, I'll again say the same thing, in only certain cases where the facts and circumstances are such, where we see that if this case, sometimes the case is not genuine. Yes, when you see that though the FIR was lodged, maybe due to some pressure, maybe due to some, good terms with certain officials there. So when you see that these cases and these powers are not, used in every day-to-day life or every day-to-day, transactions of the court. It is only sparingly used in certain cases where there is an abuse of the process of law. Yes. So as an advocate, you have a very, important point to prove in front of the Honorable High Court that it is certainly abusing the process of law, or the FIR was malicious in nature. And that where the role of the lawyer comes in terms, how do you prove it? So it would certainly change with the facts and circumstances of the case. And if you see that there is an abuse in the process of law, or it is certainly wasting the time of the judiciary, or it is of a malicious nature, or it is of a nature which is holding grudges against the accused person, that's why he has filed an FIR, then you can certainly, that could be a ground for filing a quashing petition.
Okay, ma'am. That really solved the issues. The third question is from Jayashree. In case of
Yes.
intrastate issues, matrimonial or anything, which High Court has jurisdiction to sort it? And one more is
Talking
like the caution of FI can be filed at which state of cases, at trial or before the trial cases. Should I repeat the question, ma'am?
Yes, please.
Okay, ma'am. In a case of interstate issue, matrimonial or anything, which High Court has a jurisdiction?
Okay.
Okay.
So, talking about intrastate, as far as I have the knowledge to it, whenever the case is filed, though it intrastate, talking about intrastate, though the parties must be residing in other states, but if, like example, in a matrimonial case, it is preferred, and the special rights have been given to the women, to the wife there, that the case could continue wherever the woman resides. So here, the issue would be actually in talking about the intrastate cases. No such cases are like intrastate cases. The case must be lodged in one particular state, one particular part of that particular state, right? Though the parties must be residing in different places, but as far as I have the knowledge, the case goes on in a particular place, right? So wherever the case is lodged, the High Court of that particular state, the High Court of that particular district, or maybe it's a district court, of course. So the High Court of that particular district would have the jurisdiction over that matter. What about the next question?
Ma'am, this is like the quashing of FIR can be filed at which stage of the cases? At the trial or before the trial?
Yes. Generally talking about beta, uh, generally talking about in the initial stages, it is preferred that the quashing of FIR can be done. But there is no such principle to this. If the abuse of process of law, even after the filing of the charge sheet, also, if it is seen by the Honorable High Court that there is an abuse in the process of law, and if the continuance of this case would certainly lead to the abuse in process of the proceedings as well as the wastage of time of the judiciary, it could certainly quash the FIR, even in certain cases that I have gone through, even after the filing of the charge sheet, it could be done.
Yeah, ma'am, and depending on the discretion, it
Yes,
get
yes,
quashed
yes, yes.
away.
Yes, yes, of course.
And ma'am, there's one more question is Indra Bish asked, at what stage can be FIR be quashed? Like the reason it can be quashed in the FIR stages.
Stages isn't
Yes, ma'am.
it the same kind of a thank you for the question here, beta. But it generally it is actually, I would again start, it is the discretion of the court here. Generally, uh, we what the cases that we have seen that initial stages we try to do that, but even after when the charges are framed and then it is found out that the FIR is frivolous or any other reason to that, which I have already delivered in my lecture, court do have a discretion to quash it in the later on stages as well.
Ma'am, and the fifth question deals with Vasundhara asked, what detail must not be included
Yes.
in the FIR while drafting? It's a formatting
uh,
question. Like,
yes,
what
yes, yes.
detail must not be included in FIR while drafting? Like,
Okay, Vasundhara, if you're a part of this internship program, I'm sure your mentors have told you about the facts and issue. Yes? Talking about the facts and issues here, the all the important details should be mentioned in the FIR, which actually constitute that offense. Because, as I already said, I will again reiterate the same, that FIR is a very important document that starts initiates the legal proceeding here. So in the FIR, all the important facts should be there, which actually makes the offense. And talking about any other things which should not be included, something that does not is not related to that particular offense that you are stating to, important points that you should have told to that you should have said should not be included. But I think that you should mainly focus upon what should be included. That would certainly be all the important points that would be helpful, in the later on stages. That would be helpful in the later on stages in order to, constitute an offense. Why you are saying that offense has been done against you? If you are the aggrieved, yes, of course you are the aggrieved who has been doing this, who have been filing the FIR. So as an aggrieved person, as a person who is injured in if in any case, why and what have been done against you which actually constitute the offense, the gravity of the offense should be stated in the FIR, and the important dates, the important timings, and the important things and important facts that actually constitute the offense, and anything other than that that is not related to the offense, which should certainly not be included in the FIR.
ma'am, so there's another question. So
Yes,
Saurav
please.
asked, can quashing of FIR can be done in the cases of NDPS?
Uh, talking about
NDPS, those cases.
the narcotics cases, is he meaning so?
Yeah,
The
I think
narcotics,
so,
drugs,
that
and
only.
yes, Saurav, that is a really good question, and that your curiosity. And talking about the act, the NDPS Act here, um, this basically talks about the sale, transport, and consumption of the narcotics and drugs. Yes, so this are of a grave, gravity of the offense here is a bit more, and as comparatively, uh, it is of a more how would I put it? It is of a more serious nature, beta. So, talking about its cultivation, manufacture, or sale, or purchase, or transportation of the NDPS, the drugs here, the penalties here are also very serious and very, certain and strict here. And the Narcotics Control Bureau is the, there's a regulating body under this act, beta, that controls the same. So here it is of a very grave nature and certainly affects the society at last. So as far of my knowledge, in these cases, these are of a very serious nature. So quashing of FIR, that depends upon that could be the discretion of the court. If the FIR is of a totally, frivolous nature that has been done against the accused, so it could consider the same. But if the parties try to settle the dispute between two related to drugs, I don't think that it could be done.
Ma'am, this is the question from Rohit. So he asks, it's
Yes,
an interesting question. In case where the High Court
yes.
is misusing the power of quashing FIR, what remedies we have?
So here you are trying to question
Yeah,
the
he is
High
trying to
Court.
question the court. Yeah.
Of course, that is also out of curiosity. That means you people were listening to me. I'm very happy about that. Uh, So here, my answer to this would be, uh, first of all, we would have to see what are the facts and circumstances of the case. Yes, and talking about that, whether the High Court is misusing the power here, that is of a grave question here. But of course, we do have the Supreme Court also. Yes, we do. Above the High Court, we do have the Supreme Court also. The matter could be elevated before the Honorable Supreme Court. As you could see when we are talking about the landmark judgments here, beta, when we see talking about Gyanjan and talking about the Bhajan Sangh judgment also, these judgment was not taken by the High Court. Yes, but these were the landmark judgments that was taken by the Honorable Supreme Court here. So certainly we do have an option here if it is does so, and it could be seen prima facie that the High Court has misuse their power. Then certainly we can move to the Honorable High Court and talking about the abuse of power, that could certainly be done, and sheer misuse of power can be done. So here, my submission to this would be that we do have an option to move to the Supreme Court as well if we are not satisfied by the judgment of the High Court.
This
Yes.
question is really genuine, ma'am, by Smita. She asks, based on High Court current backlog, how long does it typically take for a first hearing after filing?
Okay. First hearing of what you're talking about after filing of the quashing petition.
Yeah, ma'am. I think so. Like she's talking about the backlog the current court
Back.
having, like in the High Court.
Yes, yes, yes. That is a very, that is a very serious question here because we can also see that the High Court is also overburdened. Yes, we have seen a lot of backlog of cases here. And talking about the particular time period here, uh, particular time period after you file a quashing petition, generally I need to see that what going to the practicality after how much time the High Court would give the date here. But talking about the backlog, yes, the High Court is being overburdened and they're trying to resolve all the cases here. But I would like to just give me 1 minute. I'll just give me 1 minute regarding this question. I'll just answer on it. Yes.
Sure, ma'am.
So, beta, so if I actually go to the legal provisions here, we will strictly talk about the laws, okay? We are talking about the laws that have been given again, coming and talking about the sections 528 here. So here basically, uh, first factor that is affecting the time here is the gravity of the offense, the stage where the quashing of FIR has been, filed. What is the stage of the trial that have been going, and generally, between they have been saying that it could be the minimum of 10 days also and the maximum of 3 months also, that the hearings would go. And generally, between 2 to 5 hearings, they would certainly, take a decision upon this matter. So talking about the gravity of the offense, that
Yeah,
it
ma'am.
could be a minimum of 10 days as well as the maximum of 3 months, and around like 2 to 5 hearings, they would dispose of the petition.
Ma'am, so this is like a little question whether appeal is allowed for quashing the FIR or not from the justice. She is asking.
Appeal for,
Appeal for like in the quashing, is it allowed or not?
after the quashing petition have been, okay. Yes, talking about an appeal here. Okay, I'll just talk about the legal provision again here. Give me 1 second. I'll open the section. Uh, Talking about the appeal here, better no specific section have been given regarding the same. But coming to the judgments here, just give me a second. Hmm. Yes, beta. Talking about the appeal here, beta. Once the quashing of FIR has been given, and the FIR terminates, but the other party do have an option. Yes, though a specific, I was trying to find out whether a specific provision have been given here, but such section has not been given. But we do have a power. Students, we are aware that we do have a special leave petition as well. Yes, so we're talking about a special leave petition, that is Article 136. We do have a power. So if we don't have a special we don't have a specific section here for that, but we do have a power and we do have an option to go for a special leave petition. And here, yes, of course, the Supreme Court would intervene for the same, and they would can certainly, reopen the case, and they could certainly consider the why the quashing of orders have been given, and they could certainly read the they can go through the quashing petition again. So the yes, no specific section have been given here for this, but yes, if you go and file SLP, that is a special leave petition, that is under Article 136, you can go to the Honorable Supreme Court of India.
Ma'am, so this is the last question. I won't taking your time. This
Yes,
is from my side.
yes, please.
So, ma'am, this questions deal with like the culpable homicide, not amounting murder, can be covered under the quashable of the case because if it hold the public interest at large, because it's affecting the public, so could it be considered
Yes.
in the quashable? There's many cases
Uh,
happening in today's. So, in that sense, I'm saying
Culpable homicide not amounting to murder. You are saying
yes, ma'am.
whether the FIR could be quashed or not.
Yes, ma'am. Like because it's serious, grave offense. So
It is, it is, it
yeah.
is. Of course, it is. It is of a grave nature. Yes. So, beta, talking about culpable homicide that is not amounting to murder, as you said, uh, is of a serious nature. But talking about, I would again say, beta, that is a really nice question. But when you're talking about the prima facie evidence to it, yes, you know, uh, when we talk about the cases here in the criminal nature, we say that there is a prima facie evidence that such kind of an offense is being done. So, if culpable homicide not amounting to murder here, and if there is no prima facie evidence that the ingredients, uh, I'm sure you people know whenever you try to prove an offense, you see the ingredients, the essentials of that particular offense, and which have been given specifically in the BNS. And when you see that these ingredients are fulfilled, yes, that offense have been committed. And when you see that if all the ingredients of this particular ingredients, by ingredients I mean all the essentials of these offense are not met, then maybe the death was accidental on in nature, or maybe you can say that by prima facie you cannot see that there is an evidence that it is a culpable homicide not amounting to murder. So here the high court do here also the high court also do have a power that in order to prevent the abuse of the process of law. So first thing that you would say that it could consider to the quashing, yes, I would say so, because if these conditions are there which I am telling you, the first one is the prima facie case is absent, totally absent. Yes, unnecessary, there are unnecessary things have been said against the accused, and maybe if there is a negligence there, maybe there is a lack of certain elements which again talking about, that there are certain elements which constitute to such offenses. And Vita, there are some special cases which are quashing in medical cases. Medical cases as such, where there is negligence that have been done in case of, there is death have been caused in case of medical cases. So, yes, I would just sum up everything here that yes, quashing could be done when the evidence, there is no evidence, when mistakenly, maybe that event was an accident, or again, I would say it would maliciously done and there is an abuse in the process of law.
Thank you, mom. It do give me justice to my answer. Thank you, thank you.
Yes. Thank you so much for beautiful questions that you put through. And I have been done, yeah, it was giving brainstorming to me also, but I am so happy that they were listening and they were asking questions. And you people are doing a great job. Thank you so much for calling me.
Thank you very much, ma'am. It was just an insightful Korean sessions. There's no way we can measure your excellency just beyond our limit and beyond the boundary. That was really very great, ma'am. And we are honored to have you over here on board. Your detailed explanations truly cleared up the practical nuances for filing a complaint. And we are grateful for your patience in addressing every particular question to every interns. And interns were also listening it very carefully. So this session has been incredibly valuable for our drafting journey, ma'am. Thank you very much, ma'am, for being here.
Thank you so much. Thank you so much.
All right, interns. Briefing is done, and I don't think there are more doubts from your side. Tasks will be forwarded to your group, and Vinay Kapoor, uh, the same guy for which you have drafted the task one, has paid the money, and Aryan, the client, has signed a compromise deed. They want to stop the case, and now your job is to draft the petition that kills the FIR. And you must draft a petition for quashing of FIR to be filed in the High Court of Delhi under Section 528 of BNSS. Ma'am has already guided you by every single steps, and do not address this to the magistrate or the police station. That's a warning. Many students had already done very mistake on the tax one. Only the High Court has the power of quash. If you file this in wrong court, your client stays trapped in the system. And guidelines has already been shared, but then also I am sharing once again. The deadline for these tasks will be Saturday, 11 for the 59. That's the last timing. And You must describe the acts clearly so they fit in the cases, and you can submit on PDF or docs document both. Email your final draft directly to your team group lead's Gmail address. Do not send it to main coordinator or to the personal WhatsApp number unless it's specified. A sample will be forwarded in your group soon for your reference. Use it for structure. And if you face any issues or have doubts regarding the tasks, please reach out to your respective team lead immediately. And if not covered, we'll reach out to you. Best of luck for your tasks too. And thank you very much, man. Deepak
Thank you
sir?
so much. Have a nice day. Thank you so much. I can leave?
Yes, ma'am. Sure, ma'am. You can leave.
Thank you so much.
Thank you, ma'am. Thank you. Okay, interns, if you don't have any doubt, then we can just close it. Bye. Have best of luck for your second tasks.